Hello, my name is Michael Tesoro, and I've prepared this presentation on ACCC Search Warrants. A bit of background about myself: I'm a competition and consumer lawyer. I run my own practice, Tesoro Legal Consulting, and I've been doing that for about 13 years. I assist companies with competition and consumer law investigations and litigation. I've also had cause to assist some companies in relation to search warrants, either while they're being undertaken or after the event. So I've gained some understanding from that perspective in my private practice. Prior to working at my own practice, I worked at the ACCC in a few different roles, and one of the roles was as a Director of Enforcement. And in that role, I did have cause to use the power which used to exist in the Trade Practices Act, which is probably like a search warrant power, which was Section 1552 of the Trade Practices Act, which allowed the ACCC to go and search premises for evidence about breaches of the Trade Practices Act. And probably the most significant one that I did was I ran the team, or was in charge of the team that went to execute the search warrant or the Section 1552 notice at the Caltex Bank's Meadow site in the very ill-fated ACCC investigation into the petrol companies. So the outline of the presentation, I'll start off with a bit of an introduction, then go through the legislation in quite a bit of detail, then talk you through some practical tips, which you should remember if you're ever in the position of having to respond to a search warrant. Then I'll use a case example which arose from my private practice, which I think raised some interesting issues about what to look for when your client is subject to or you are subject to a search warrant, and finally a bit of commentary about the ACCC's powers. Just very quickly, this presentation is based on an article which I wrote many years ago in 2011 for the Keeping Good Companies Journal, which was put out by the Chartered Secretaries. It's now called the Governance Institute. And obviously I've updated it a bit since 2011, so there's some updated information in this presentation. Now, some statistics that are quite interesting relate to the use of search warrants by the ACCC. The power came in 2006, and I've calculated that during the period from 2006 to June 2021, the ACCC had issued 55 search warrants. So you can see that's over a 15-year period. They've only issued, 55 search warrants, which is quite a low number. But I think the most important aspect is looking at how the usage of search warrants has increased in recent times. So in the 2-year period prior to COVID, 2018-19 and 2019-20, the ACCC issued 23 search warrants. So as you can see, in the first 12 or so years, the ACCC has only issued 32 search warrants, and in a 2-year period, they've risen to 23 search warrants. So obviously during COVID, they stopped using search warrants, but once COVID's passed, they'll be back issuing search warrants, and I suspect the level of usage will be comparable to the 2-year period prior to COVID. So 20 odd search warrants a year is probably going to become the norm going forward, particularly investigating criminal cartels, a very useful investigatory tool. Now, the key area is Part 11D of the Competition and Consumer Act, which contains relevant provisions, and the starting point is Section 154X, which effectively what the ACCC has to do is prepare an information, usually by the lead investigator, and go to a magistrate in the local court and satisfy the magistrate that there are reasonable grounds for suspecting that there is evidential material on particular premises currently or within the next 72 hours. So if they can satisfy the magistrate that there are reasonable grounds and the evidential material is present or will be present shortly, then the warrant will be issued. Now, prior to approaching the magistrate, the ACCC has to appoint an inspector who will be the person mentioned in the search warrant, but also responsible for executing the search warrant and making decisions about what's evidential material. And also they have to issue the inspector with an identity card. And the inspector is required to carry the identity card throughout the execution of the search warrant, and also produce the identity card to the occupiers of the premises on request. The timing issues are very important for search warrants. Effectively, when they're issued, there is a lifespan of 1 week. So they have to be issued within 1 week of the magistrate signing off on them. And if it goes over that week, they're no longer valid, can't be executed. The other thing is sometimes search warrants will specify times that they can be executed. They might say it has to be executed during business hours or can't be executed on a weekend. So if there's any of those details specified in the search warrant, they have to be complied with. And then with the execution of the search warrant, Division 4 governs what the inspector can do when executing a search warrant. Obviously, they can enter the premises, they can search the premises looking for the evidential material, which they tell the magistrate is on the premises. They can seize evidential material, they can make copies of the evidential material, they can be photocopying them. They can also operate electronic equipment to access, but also to copy evidential material, and they can obviously are permitted to bring equipment onto the premises that they need to use to, say, image computers and take copies of computers. Now, during the execution, the ACCC will show up with a couple of Australian Federal Police agents who will assist the ACCC in the execution of the search warrant. Usually that is just helping the ACCC get access to the premises, and once the ACCC has got access, the Australian Federal Police agents will leave. I know when I did the Section 1552 notice on Caltex, the AFP agents ensured that I and my team got onto the premises, and once we achieved that, they left to do other things. But they are permitted to use force to execute the search warrant, so if anybody seeks to obstruct the ACCC in the performance of their duties, they will arrest that person, and they're pretty keen to do that generally. And also, there's an obligation to announce the entry. So ACCC's got to tell the occupier, I'm here to execute a search warrant, and then allow the occupier an opportunity to let them in, and then provide the occupier with a copy of the search warrant. It's interesting, I was involved in a different search warrant when I was back at the ACCC, and we did a briefing with the police, and just before we left to do the execution of the search warrant, they opened this cabinet and started taking out sledgehammers and bolt cutters. So when there's a real belief that getting access to the premises may be difficult, the police have no hesitation using genuine force to get access to the relevant premises. As far as I'm aware, the ACCC doesn't tend to bring along sledgehammers and bolt cutters to their execution of their search warrants. An important issue to remember is that the ACCC is permitted by the legislation to take photographs and make video recordings of anything happening at the execution of the search warrant that's incidental to that execution. And the way the ACCC does this is that they video effectively everything, video the entry into the premises. When they search various areas, they'll video that. They'll ask occupiers and employees of occupiers questions and video that as well. So there'll be a large number of videos generated during the course of a search warrant. I did once try to put a FOI request in on and gain access to a number of these video recordings, and my request was rebuffed on the basis that it was not disclosable material, these videos, because they would have revealed ACCC investigatory techniques. So it's a good thing to know that these videos aren't things that you can get access to in the ordinary course of an FOI request. You may be able to get them under discovery, or potentially they may be tendered in court. Okay, so it's important to understand this distinction between moving and seizing items. So under section 154GA, the ACCC is able to move anything found at the premises to another place for examination or processing. So this might be a physical item, this might be a computer, something that it believes may have some relevance to the investigation, but it might be a large database or something like that, which they don't have time to carefully look at, or it might involve the use of some other software or equipment to actually extract information from it. So if they do move anything from the premises, then they are permitted to examine and process it as at another location. But the key thing here is if anything is moved from the premises, the ACCC has a couple of obligations. Firstly is they must inform the occupier of the premises when they intend to examine or process the thing they've removed, and also the place where they're going to do that. And they must allow the occupier the right to be there when they examine or process the device or whatever it is, or a representative, so a lawyer of the occupier. So I think this is based on the idea that there's a risk if the occupier or their lawyer is not present when the item is being examined or processed, that it may be tampered with. There's an evidentiary concern that the documents or other aspects of the device may be compromised in some way, or something manufactured to suggest guilt. So it's important to have a person there for the occupier looking over the ACCC shoulder. The second protection that occupiers have is that anything that is moved from the premises must be returned within 72 hours unless the ACCC gets an extension from a magistrate. So it's important to remember, if they've removed some computers from your premises, that you have to be there when they're looking at these computers and examining and processing them, and also they've got 72 hours from the time they were removed from your premises to give them back to you. So you really should be carefully monitoring the times when things are removed and when they need to be returned. Then there's also a provision about seizing data. And as the section says there, if the executing officer or inspector believes on reasonable grounds that data accessed by operating electronic equipment might constitute evidential material, they may do one of three things. Now, it's an interesting thing. The first thing is to seize the equipment and effectively take it away. But that's the last alternative, effectively. Really, what they firstly must do is, if they believe that there might be evidential material on some electronic equipment, they are permitted to operate their own equipment to take copies of that data, put it into a documentary form, and then print it out and remove those documents. The second alternative is to actually operate electronic equipment to copy data from the occupier's computer onto a disk tape and then take that away. But the last option is to actually take and seize the equipment and take it away. And it's interesting to understand the differences between moving and seizing equipment. Moving equipment is when you really don't have time to look at it, you don't know what's on there, and there's certain protections which apply, because you can't really have regulators examining and processing data without the occupier being present. Here, ACCC can't take any equipment away, any information away, any equipment away, unless they first satisfied themselves that there might be evidential material. So it's important, when the ACCC is taking any electronic equipment from your premises, that you clarify, are they moving it under the previous provision, or are they seizing it under this provision? You've got to ask them. And if they say they're seizing the electronic equipment, you are within your rights to say to them, have you formed the view that there may be evidential material on this electronic equipment, and that you're unable to copy the relevant information from this equipment, that you really need to remove it from the premises, to seize it and remove it? You need to ask them that question and have some clarity. I had an ACCC case where the ACCC moved some documents, some equipment from the client's premises, and then returned it in 72 hours. And when I raised an objection to the fact they hadn't allowed the client the opportunity to be present when they examined and processed the material, the ACCC claimed that they'd actually seized it. They hadn't moved it, which I was a bit sceptical that that was actually correct. It's very important to understand whether the electronic equipment is being seized or moved, because you have rights in one case and less rights in the other case. Now, the Occupiers have various rights and responsibilities. The first is the occupier is entitled to observe the search as long as they don't get in the way and impede it. Also, the occupier is required to provide the ACCC with reasonable facilities and assistance. So that means that they have to provide access to photocopiers and maybe scanners and other devices that may be at the premises, but they've also got to answer questions. If the ACCC asks somebody where the filing cabinets are, you have to tell them. And I remember when I did the Banks Meadow Caltex effectively search warrant, I did ask them where the filing cabinets were, and they were in this very remote location, so I was able to go there and conduct a search. Also, the executing officer has a right to ask occupiers questions and to request the production of evidential material. This is one off-putting thing, and staff need to know this, that the ACCC are allowed to ask questions and are allowed to ask where evidential material is and to ask it to be produced. And if the occupier or its employees don't comply with these requests, they can be prosecuted. And the prosecution is something that the ACCC would take quite seriously. As you can see, there's a penalty there of $3,300 or a maximum of 12 months imprisonment. Further rights and responsibilities of occupiers involve the ACCC being required to provide the occupier with copies of all the seized material on request, and so that's something that you could ask depending on the size of the material or the amount of material taken by the ACCC for a copy on the day. More likely you'd write to the ACCC the day after and ask them for a copy of all the material that's been seized. Also, you have a right to obtain a receipt for all the evidential material that's being seized or moved. So clearly the day after the search warrant's being completed, you should write to the ACCC and ask for a receipt, particularly for details of any equipment moved under section 154 GA1. Also, it's important to know that any evidential material that's been seized must be returned to the occupier within 120 days or when it's no longer needed. So realistically, you're probably talking about 120 days, and you put that date in your calendar, and clearly a few days prior to the 120 days expiring, you should write to the ACCC and ask them to return the material by the 120th day. Now, just to understand a bit of background about the way the ACCC does search warrants, often it's based on insider information. They've got somebody, a former employee who's given them information, told them where things are, and maybe even assisted the ACCC in preparing a bit of a floor plan. I know that once I had an informant who was a former employee, and he helped me prepare a floor plan of the building, and so I knew where everybody was seated and where their offices were and things like that. Also, immunity applicants are often the source of the information, so they'll know the relevant individuals who may be involved in some alleged illegal conduct, may also know the terminology that is important to be able to identify documents on a database. So there's a lot of insider information, so ACCC is quite sophisticated and will know a lot of background information. Secondly, there's an enormous amount of planning. I remember when I was involved in the Caltex search warrant that we spent about a week planning every last aspect of the section 1552 notice, including timings of when we were going to arrive and all the rest of it. A large number of staff were involved, and this can be very intimidating. I know there was a small company that was going to be investigated for some consumer law breaches, and they told me that 30 people have showed up to execute the search warrant. There was a couple of AFP agents, some forensic IT guys, and the remainder were ACCC. They showed up in 2 large vans. So there'll be a large number of people arriving on your doorstep unannounced, and it's a very intimidating experience. Now, here's a few practical tips. When you get approached by the ACCC and they've got a search warrant, they'll give you a copy of it. You really should sit down and carefully check the search warrant to make sure it complies with the legislation. The first thing is to look at is whether they've described the premises right. Now, if you're 154 and the search warrant says 156 on a particular road, then that would make the search warrant invalid and you can refuse entry. So clearly ensure that they've described the premises correctly, that they've got the right street address, and that isn't a theoretical possibility. I remember the ACCC issued a search warrant on a company once, and it turned out to be the wrong location, and they had to rush off and get a replacement search warrant and go to the correct location, which is embarrassing for the ACCC. Also, the search warrant's got to have details of the kind of evidential material they're looking for, as well as stating the alleged contraventions. Now, this is a difficult one to sort of raise too much of an objection to, but if the warrant is just totally deficient, doesn't say anything about the kind of evidential material they're looking for or any detail about alleged contraventions, I think you'd have an opportunity to refuse access to the premises. But more likely, this is the type of issue that might have to be agitated later on after the search warrant has been executed. Also, you've got to look for the name of the inspector who's responsible for executing the warrant. Make sure that's the same person who is providing you with the search warrant. You also should ask to see their ID badge. It's not unheard of that some people may forget to bring their ID badge to the execution of a search warrant. If they don't have it on them, you don't have to give the ACCC access. So definitely check the name of the inspector of the warrant, ask to see their ID badge. Also, look at the times when you're able to execute the search warrant. If it's in particular hours or excludes the weekend, and if it arrived at those times, you can again say that they can't come on to the premises, into the premises. An important thing here is that often you won't be allowed to commence a search warrant before a certain time, like 7 in the morning, but you can stay until the job's done. And I remember when I did the Caltex one, I arrived at about 7 in the morning with my team, and I think I was the last person out about midnight. And if the ACCC can't finish their search by at the end of the day, they can seal up the premises and come back the following day. Finally, the day that they execute the search warrant can't be more than a week after the issue of the warrant. So if it's more than 7 days, the search warrant has ceased to have effect and you can refuse the ACCC access. Some further practical tips about execution. Often there's a bit of a debate. Some lawyers say you should ask ACCC to hold off executing the search warrant until their external lawyers can get to the premises. It's fine to ask, but realistically, the ACCC does not have to agree, and it really shouldn't agree when you think about it, because a search warrant is a surprise investigatory tool, and it doesn't make a lot of sense to allow a delay of half an hour until the occupier's external lawyers get to the premises, during which time lots of evidential material could be destroyed. So you can ask, but I think the ACCC is very likely to say no to that. Then this is an important aspect. It is very intimidating. There's lots of people walking through the premises. It is very advisable to send an email around to all staff at the premises, advising them that the ACCC are on the premises and are executing a search warrant, and also to specify what they're required to do: provide assistance, answer questions, not obstruct. And the key thing here is not just to shoot out an email and then the ACCC discover it. Best to have a template email prepared and then fill in the relevant details, show it to the ACCC, ask for the permission to send it around to staff, and then send it around to staff. So that's a very advisable step to take, because it will reduce a lot of the tension, will ensure none of your employees do anything they shouldn't do and end up getting arrested. Another thing that people do is sometimes put all the staff into a room and keep them away from the ACCC investigators. It's a natural reaction, but realistically, what you should be doing is getting the relevant staff in a room and breaking them up into teams to observe the execution of the search warrant. Because if a mistake is made, or if there's some interesting observation that you could make of the ACCC executing their search warrant, then we want to be positioned to be aware of that information. So I think the best thing is to break your people up into teams and ask them to observe the search. It's also good to tell your staff not to delete data from computers while the search is going on, because even though it's unlikely to be anything untoward, it looks very suspicious. And also, don't use shredders. I know that when I've done some search warrants, first thing I did was unplug all the, direct my staff to unplug all the shredders in the building. Now, another reason you should send teams around to observe the search is in relation to legal professional privilege claims, because if the ACCC starts going through a filing cabinet and comes across some files that are, marked as privileged or the work product of your in-house lawyer, you want to be in a position to point that out to the ACCC and ask them to put that material in an envelope and to seal it, on the basis that you'd be proposing to make a privilege claim over that material at a later date. So you've actually got to be watching what the ACCC is doing, looking at what they're getting access to, and pointing out anything that could be subject to a valid privilege claim, but effectively that it's not looked at until the privilege claim is worked out and kept away, particularly from the investigators who may be running the case. Now, it's important when you're looking at the cases in relation to search warrants just to understand how strict the courts are with observing the formalities of the law in relation to search warrants. So here's one of the leading cases by the High Court, George v. Rocket, where they're talking about, this is a very invasive power. We're allowing people to come into people's businesses or their homes and to obtain information from them. And so really it's important that the courts ensure that the search warrant has been lawfully issued, properly executed, and the courts will insist on very strict compliance with the statutory conditions around the search warrant. So that's the first thing to realise, that the courts will strike down search warrants where there's been a departure from the formal requirements. The other leading case is Ousley, and in this case the High Court talks again about it's a strict approach needs to be taken to the execution of search warrants. And I like the quote here that it's not some quaint ritual of the law requiring a perfunctory scanning of the right formal phrases perceived but not considered and followed simply by an inevitable signature. And then the conduct of the person issuing the warrant must be no mere cipher, careless of the fundamental rights of citizens. So again, the courts are very conscious of making sure that the formal requirements are complied with. Now, this case was a case I was involved in private practice, and it just shows you how a careful monitoring of what the ACCC has actually done could disclose a number of errors. So this was a cartel investigation involving a number of companies who were served, one of the parties was served with a search warrant. And when we carefully examined what the ACCC had done in this particular case, it became clear that they moved some electronic equipment from the premises, but then it failed to comply with the obligation to advise the occupier of the time and place where they were going to examine or process this particular electronic equipment. So that effectively moved some electronic equipment away, examined and processed it by themselves without the occupier being allowed to go along or send a lawyer along. So we raised that as one of the breaches of the relevant legislation, which obviously created some problems. Then there was a further issue about the forensic IT company hired by the ACCC had some technical issues in seeking to process the data on this electronic device, and then the device was returned to the occupier within 72 hours. And then after that date, the forensic IT company reran their software and was able to download a lot of information. This is talking about a mobile phone. So here you've got a situation where you're not allowed to move a device and then make a copy of the entire device and then return the device and then subsequently examine and process the backup you've made. That's a clear breach of the relevant legislation. And then there was also an idea that, or a problem with the conduct of the forensic company that was hired by the ACCC, because they'd gone through the material which they downloaded from his phone, which was quite probative, and they'd identified material which they believed was evidential material, and then they just printed it out and dropped it off at the ACCC's offices. Now, there's a lot wrong with that. Firstly, the only person who can make a claim or a call on what's evidential material is the inspector, the person authorised to execute the warrant. It can't be done by some third party that's not even employed by the ACCC. So that was the first breach. Secondly, you can't just deliver evidential material to the ACCC. If it's in the possession of the forensic company, then it's got to be seized from them. So that was what the ACCC was seeking to do in this particular case, and they'd realised the mistake made by the forensic IT company, and they were seeking to execute a further search warrant on that company to obtain material. So it was a bit of a mess, the whole thing, and there was a few lawyers involved. We wrote a joint letter to the ACCC, sort of somewhat ironic in a cartel investigation, but we pointed out all these mistakes which we claimed the ACCC had made, technical mistakes, but important mistakes, mistakes that meant they had avoided some of the protections that were provided under the legislation, that they'd obtained material improperly, and it was probative material. So we argued that not only had they made serious mistakes, but they'd obtained evidence illegally, which had thus corrupted the whole ACCC organisation, and they could no longer continue the investigation. So we actually raised the ACCC and said they should drop the whole investigation. I think it's fair to say that ACCC did not admit to us that it made mistakes. It was sort of quite silent on that particular point, but the key issue here is that they did drop the whole investigation. We got a letter from the ACCC a couple of weeks later saying that they weren't going to pursue the investigation any further. So the point I'm trying to make here is that if you carefully look at all the things the ACCC is doing, not just during the execution of the search warrant, but after the event, particularly with when they're moving material, electronic equipment from your premises, when they're seizing material, if you carefully examine all that, you may be able to identify some errors, and if an error is made, the courts generally will be quite unsympathetic to the regulator. Now, just in terms of going forward, hopefully this presentation has given you a good outline of the law and some practical tips, but the key to being able to respond to a search warrant is to be prepared. And the question is, how do you be prepared for this eventuality? I think the key point is to very, very closely monitor all stages of the search warrant. And that's somewhat counterintuitive. It's a very stressful experience. But if you're sending your staff an email during the search warrant, explaining what's going on, and then you're breaking people up to teams to monitor the execution search warrant, and then a couple of days later you have a debrief and you get all the information from the employees, then you've closely monitored the execution search warrant, the chances of you picking up a mistake are much higher. The second thing is you've got to ensure your staff are trained, because whilst this doesn't happen that often, it looks to be an increasing use of search warrants, and the stress associated with a search warrant is very high. I don't think anybody expects to get a search warrant, so it always takes people by surprise. It's very important to train your staff, to develop, training modules for your staff, particularly receptionist staff, because they're going to be on the front line. They're the people who are going to be there when the ACCC walks to the door with a couple of AFP officers and some forensic computer people, and they've got to know what they're doing. Furthermore, you've got to have clear policies and procedures, and also the relevant contact people who are going to be in the centre of this when it happens, and that's obviously in-house counsel, but other people that you may not ordinarily think of, like your IT manager should be part of that team, because they're going to be a key person the ACCC is going to be asking questions about. The person in charge of your filing systems is another key person. So you've got to have a key team with contact details, and they're going to be the people who interact with the ACCC and answer any relevant questions. And then finally, once you've got these documents, policies in place and provided training, it would be advisable, it would be a good idea to maybe organise a mock execution of a search warrant at your premises. Obviously, it'd have to be done without any forewarning, and maybe get your external lawyers to come in and pretend to be ACCC officers. But I think that's the way you're really going to understand the way this whole scenario works and what to look for. So that's all I had. Hopefully that's quite helpful. I've had a bit of experience in relation to this area, and it is a very stressful experience. And the best way to reduce the stress of a search warrant is to be prepared. So there's a few practical steps in there to implement and to reduce the stress. So if you have any questions about any of this, feel free to give us a call or drop us an email. Bye-bye.